Okay, good morning everyone and welcome to this Kuits webinar for business owners and HR professionals who currently have the enviable job of managing their workforce through the ups and downs of this COVID outbreak. My name is Sarah Glynn and I'm the marketing manager for Kuits. For those of you who don't know us or don't already work with us, we are a law firm based in Manchester City Centre. Obviously, we're not coming to you from the city centre today. We're coming to you from the spare rooms and, in my case, the kitchen table of our houses. So this is the second COVID-related webinar that we have produced since the start of the outbreak. And on the first one, we did have some doorbells going. We had the postman knocking. We had some grandfather clocks chiming in the background. So please do forgive us for any sort of small interruptions that we might experience over the course of the content. So just before we begin, a little bit on what Kuits has been doing since the start of the outbreak, really to help businesses stay on their feet and hopefully be in a position to prosper when we get to the end of this. I won't go through this in any great detail, but I think it's enough to say that if you do have any issues, any commercial or legal issues that you require advice on, please do get in touch. If we can't help you, we will know someone who can. So please do feel free to get in touch with us at any time on any topic. So the agenda for today then, we'll be speaking to you for around 30 to 40 minutes before we hand over to you for questions. I'm just going to be going through a little bit of housekeeping and ways to connect with us after this webinar is over. I'll then be handing over to our Head of Employment, Kevin McKenna, who will be giving us a bit of a greater introduction to the team and the topic. We're then going to look at the coronavirus job retention scheme, which many of you I'm sure will be partway through by now, before we move on to looking at how to carry out a fair redundancy procedure and the laws and regulations that surround those procedures, as I say, before we hand over to our Q&A. So a few different ways to connect with us then. The main one that I would urge you to do is to visit our website. There you will find the COVID-19 Knowledge Centre filled with practical articles and insights on how to help you mitigate the impact of this crisis on your business. From there, you'll also be able to find a form to join our mailing list. We send out a weekly e-bulletin on a Friday, which contains all of the most recent insights that we've produced that week on a whole host of topics from HR to supplier contracts and negotiations with your landlord, so all different topics. The employment team at Kuits also have a monthly HR e-bulletin that you'll be able to sign up for, and we also have our quarterly HR breakfast club, which I know many of you that are attending this today also join us for, so please do join the mailing list and you will get the invitations to all of those things. So a little bit of housekeeping then. Obviously we're not coming to you from our office today, so there's not much to go through. I don't need to show you where the fire exits are or anything like that. So really it's just to how to ask a question. So if you move your cursor around on your screen, there should be a button at the bottom of your screen called Q&A. Please do ask questions all the way through as they come to you, although we will just be coming to them at the end to answer them. You will also have time at the end to ask any questions that you might have. Just something to note with questions, obviously due to the sensitive content that we'll be covering today, you will be able to ask questions anonymously. This webinar is also being recorded, so we wanted you to be as comfortable as possible with doing that, and you can be quite specific asking anonymous questions. And then following the webinar today, you will be receiving a follow-up email from myself. That will include the link to the recording of the webinar if you want to share that with anyone else in your organisation. I'll also include all the contact details of your speakers for today, so you don't have to worry about writing any of those things down at the end. And we'll also include links to the mailing list and other events that we've got on that I mentioned a few moments ago. So really happy to introduce your speakers for today. So we have Treacy and James Howarth, both colleagues in the employment team, both with lots of experience in helping businesses deal with the impact of the COVID crisis. And they've been key members of the COVID task force that I spoke about a few moments ago. So both very well versed on all of the different issues that companies are having at present. So I'm just going to hand over now to our Head of Employment, Kevin McKenna. He will take you through some more detail about the team and who we act for before introducing you to your first speaker. Over to you, Kevin.
Thank you, Sarah. So good morning, everyone, and welcome to my kitchen. I head up the employment team here at Kuits, an employment team of 6 specialist lawyers, 2 of whom will be speaking to you today. There are some badges on your screen, tell you a little bit about give you some more information about who we are. We are finalists in the employment team of the year for the Manchester Legal Awards. We're also recognised by Legal 500 uniquely for our work acting for employers and employees. I think we're the only law firm in Manchester that is recognised for both, and we are top tier. Not only do we advise people about the law, but clearly we are employers ourselves. So we have to put some of these things that we talk about now into action, and we have been awarded the Employer of the Year award by the City of Manchester Business Awards. So I suppose we like to think that we come with some credibility. Who do we act for? Well, we act for people like you. We act for businesses across a range of sectors, and particularly sectors that are affected significantly by the issues that have been brought about by the coronavirus outbreak. So in particular, we do a lot of work with the hospitality sector who've been hard hit, but also with a range of other businesses in manufacturing and professional services and so on, the full gamut. And we act from small businesses to large, lots of owner-managed businesses, the full range. Our role in helping businesses through the crisis has been manifold. So we've been producing updates. There are clearly webinars such as this, but we are also providing assistance in a really practical way by producing documents for clients, scripts, letters, agreements, hand-holding clients through the situation, or being a sounding board for our clients. And our key aim throughout all of this difficult minefield, which is changing really all the time, is to be approachable and practical, as James will come on to in a moment. The landscape in terms of the law and the guidance has changed rapidly, and it's been part of our job to ensure that we are on top of that for you, our clients, and for you, some of you, potential clients. With that, I'm going to hand over to James. I will return at the end in order to try and help us battle through any questions you've got. But for now, allow me to hand over to James.
Thank you, Kevin. Good morning, everybody. So my name's James Howarth. I'm a solicitor in the employment team at Kuits. And today I'm going to talk to you about furlough. I think it's a word that I'm pretty much saying in my sleep now. I've said it so many times. But I think it's just worth going through the basics first, and then I'm going to go through some of the updated guidance. So employees can be put on furlough leave if they would otherwise have been dismissed or made redundant. Whilst on furlough leave, they can't undertake any work for that employer. And work is very loosely defined as the provision of services and or making money for that employer. They can, however, undertake training. They can also get a second job as well. And you might have seen in the news recently that the government are encouraging furlough workers to work in farmers' fields, for example. HMRC will reimburse 80% of furlough workers' salary, and that's up to a cap of £2,500. The reimbursement includes wages, national insurance and pension contributions. However, it doesn't include commission unless it's a contractual obligation in the employee's contract of employment. and it doesn't include bonuses and tips, so anything that's discretionary. There's no obligation on the employer to top up the extra 20%. However, if you do decide to do that, it should be done consistently across the board so as to avoid any discrimination claims. The scheme runs from the 1st of March and it's now been extended to end on the 30th of June. Employers need to designate employees as being furloughed, and ideally you'll get some form of written consent to that designation, and I'll touch on that a little later. Employees can be furloughed for a minimum of 3 consecutive weeks. So that means an employee could work for 3 weeks, could be on furlough for 3 weeks, could come back to work for 1 day, and then be put on another three-week consecutive period of furlough. And finally, it's up to the business to decide as to who is furloughed. An employee cannot say, I want to be furloughed, and the employer has to agree. However, if you do decide to furlough maybe a certain individual in a team and not the whole team/department, you should undertake some kind of selection process and keep a record of that, because that's a great defence to any kind of discrimination claim that might come later down the line. So we've had some clarification from the government on a number of outstanding issues, the first of which is re-employing staff. So the scheme was recently amended so that any employee who left their employment after the 28th of February, and that could have been through resignation, dismissal or redundancy, but was then re-employed by the same employer, they can then be put on furlough leave. And that is so long as they left their employment before the 19th of March. So effectively what the government has done is they've extended the deadline from the 28th of February to the 19th of March. So that brings another consideration. If you do have an employee who you have re-employed, continuity of service could continue. So say, for example, you have an employee who's worked for 23 months. You dismiss them, then rehire them after a couple of days, and then they're on furlough leave for 2 months. Technically, they'd probably have more than 2 years service at that point, and therefore have protection against unfair dismissal, which would make dismissing them a little bit more difficult later down the line. Practically, as well as what we've seen from clients accessing the HMRC portal to claim this reimbursement, is that you can only recover salary in the month that it was incurred. So what that means is you can't bring 2 months of wage claims in a 1 month period. So in this month it's slightly different because there's a look back, but moving forward that's not the case. So if you have re-employed any worker, you'll have to make a claim this month for their wages. You can't wait till next month. The second clarification we've had is around 2P. So a new employer is eligible to claim under the scheme in respect of employees of a previous business transfer after the 19th of March, if either the 2P or PAYE succession rules apply. So if an employee is 2P transferred across, you can then furlough them. And the final clarification we've had is around national minimum wage. So an employee placed on furlough leave is not considered to be working under national minimum wage rules. This means that if you do take a pay reduction and you pay them less than national minimum wage, an employer, you do not have to top up the difference. However, this is slightly different if they're undertaking training. So for some reason, furlough doesn't consider training to be working, but the national minimum wage does consider training to be working. So if you've got an employee who's on furlough leave, he's being paid less than national minimum wage, and he's undertaking training, you'll have to top up that difference. So the next thing I'm going to talk about is some updated guidance from the government, the first of which is around annual leave. So it's now been confirmed that an employee can take annual leave whilst on furlough leave. However, you must top up the normal salary to the normal rate of pay if they're on holiday during furlough leave. And this is for any statutory holiday, so the 5.6 statutory holiday weeks they'll get. This is not the case for any contractual holiday above that, and that can be paid at a lower rate. But any statutory holiday has to be paid at 100%. Although it's not been confirmed yet, we think it will be the case that employers can tell employees to take annual leave whilst on furlough leave. But that will be subject to the usual notification rules under the working time regulations. So that means you need to give double the notice of the holiday you want an employee to take. So if you want them to take 1 week's notice, you need to give them 1 week's holiday, sorry, you need to give them 2 weeks notice, for example. The final thing to touch on annual leave is around bank holidays. So if a bank holiday is considered to be annual leave in an employee's contract, then it's likely that you have to top up their wage to the normal rate of pay if they're on furlough at the same time. The next guidance update we've had is around agreement to furlough. So a normal employment law doesn't necessarily require an agreement to be agreed in writing to be binding. So take a contract of employment, for example. Both parties don't necessarily have to sign the agreement for it to be binding, so long as both parties are working to those agreed terms. And previous government guidance supported this. So what the government said previously was there needs to be a written record of the agreement, but the employee does not have to provide a written response. All good. However, on the 17th of April, there's been a Treasury direction, and that contradicts directly with previous government guidance. So what that direction says is that you can only access the scheme where the employer and the employee have agreed in writing that the employee will cease all work in relation to their employment. So the key thing there is the employer and the employee have agreed in writing. So that's a clear distinction from previous government guidance. And technically, the Treasury direction is binding, whereas government guidance isn't. So what we're going to have to do is we're going to have to wait for clarity on this. But that being said, I tend to kind of agree with the government position, really. I think the Treasury guidance isn't necessarily correct. It just seems contrary to employment law and what we tend to see. And it also flies in the face of the practicalities of the situation we're in. It's going to be very difficult for a lot of employers to get employees to provide that written response. And I doubt that the Treasury intended to go further than what the government said. So again, we'll weigh guidance on this. And I think in the first instance, it's going to be best to try and get that written agreement from an employee, even if that is a retrospective. You can still do that at this point. So the next guidance update is around SSP. So previous government guidance has been really clear on that, and they've said that if you're on SSP, you can't be put on furlough leave. However, the Treasury update, that Treasury direction that came in April, that contradicts that, and that has now said that it's at the employer's discretion as to whether to put an employee on furlough leave or SSP. And government guidance has been updated to correspond with that, so that will be the correct position moving forward. They've also clarified something that's pretty obvious, that an employee cannot be paid SSP and receive furlough payments at the same time. So the next updated guidance is from the Department of Education, and this relates to educational organisations accessing the job retention scheme. And this really is a cautionary tale. It appears it only applies to the education sector, but it kind of chimes with what Kevin was just talking about, that it really does apply. It's a real good example of that applies to all of us, really. So take, for example, a nursery. So a nursery has now been told by the government that they're only entitled to claim under the scheme for any private funding that they receive. So say they get 50% private funding, 50% public funding. That means that for only 50% of their employees are allowed to participate in the job retention scheme. So I say cautionary tale because it just shows that a lot of what we're seeing is just government guidance. It's not legislation, and government guidance can and does change, and this shows that. This is a fundamental change in the education sector, and it will cause substantial harm. Many businesses will have relied on previous government guidance that they could access the scheme in full. However, they're now being told that their access is actually limited. It shows that the scheme and furlough leave in general really is a moving picture. And I know the advice that we're giving does change day on day. And it also shows it really is necessary that you seek appropriate advice as and when the guidance changes. So the last thing I'm going to talk about is the HMRC portal, and that went live on the 20th of April. And from speaking to clients, what we're seeing is actually it's quite a good system, and there's not been that many difficulties aside from maybe the first few days and hours where there's been a lot of people accessing it. But in general, it seems to be working. The information you need to make a claim is listed on the government website, so I'm not going to go through that. But what I will say is, I understand you've only got 30 minutes to make your claim, otherwise it'll time out. So make sure you've got all the information you need beforehand, before you start that. Also, if you plan on making a claim for 100 or more employees on furlough, you need to include a separate document, and that'll be a spreadsheet that contains the information that you need to make the claim. Interestingly, if you've got 99 employees, you can't load the document. So if you've got less than 100, make sure you have enough time to make that application for each of them, because you've got to do it manually. Once you've claimed, you'll get a claim reference number, and then you should get the money within 6 working days. So I think that should be from the 30th of April. You should keep a copy of that claim reference number and any calculations that you made as evidence of your claim. You need to keep that for 5 years. And that shows that HMRC will retrospectively audit this. So it's very important you keep all evidence that you made the claim properly at the time. So that's it for me now. So I'll pass you over to Claire. Thank you very much.
Morning everybody, so my name is Claire Treacy. I'm a solicitor in the employment team here at Kuits as well, and this morning I'm going to talk to you about how to carry out a redundancy process, with a particular focus on how to carry out large-scale redundancies and the problems that businesses may face doing this while their employees are working remotely or on furlough leave. So the main purpose of the furlough scheme that James has just spoken about is to avoid businesses having to make redundancies during the COVID-19 pandemic. However, unfortunately, many of you and other businesses may find themselves in the position that at the end of the furlough scheme, you are going to have to make redundancies. So if we just talk about what a fair redundancy process is, if a business proposes to make redundancies, then a fair procedure must be followed to avoid a claim of unfair dismissal for employees that have over 2 years service. So I appreciate that many of you have probably had to make redundancies before, so I'll only go into this very briefly. But first of all, you must decide the appropriate pool of employees that are at risk of redundancy and inform them. You must then establish a fair and objective selection criteria that the employees can be scored against. And once you've done that, you must then consult with employees on an individual basis to discuss ways that their redundancy could be avoided. So as I said, most of you have had to do that before. But if we now look at large scale redundancies on the next slide, then hopefully this is something that many of you haven't had to do, but may become the reality now. Now, if an employer does need to make large scale redundancies, and by this I mean more than 20 employees, then there are additional obligations to collectively consult. And these additional obligations relate to if you need to make more than 20 redundancies within a 90-day period in any one establishment. The duty to collectively consult is fairly complex anyway, and it's not going to be made easier by the fact that, like I said, many employees are actually currently out of business at the moment, and the fact that we're being drip-fed government guidance about the furlough scheme. So for those of you who aren't familiar with collective consultation, it effectively puts a stop on making employees redundant for a specified time whilst the consultation is carried out. And those specified times are as shown on the slide. So if a business intends to make 20 or more of its employees in an establishment redundant within a 90-day period, then you must collectively consult with them for at least 30 days. Whereas if you need to make or propose to make more than 100 redundancies in this 90-day period in one establishment, then you must collectively consult for at least 45 days. Now, it's only after those time periods have lapsed that the redundancies can take effect. It's a common misconception that the collective consultation itself must last for the whole of these periods, but that's not correct. What it is that these are the minimum periods between the start of the consultation and the date when the first redundancy can take effect. So the minimum 30-day and 45-day periods mean that if a business needs to make redundancies immediately following the end of the furlough scheme on the 30th of June, it must start the collective consultation period on the 30th of May if it intends to make between 20 and 99 redundancies, or on the 15th of May if it needs to make 100 or more redundancies. Now, these dates are obviously only a few weeks away, and so the key here is that businesses are planning ahead. It is something that we're already being asked questions about from clients, so it is something that businesses are planning for, and it's something that we would urge you to think about if you think it's going to impact your business. So as you'll see from the slide, the requirement to carry out the collective consultation procedures relates to the number of redundancies in an establishment. So just briefly speak about that. So it's just on the other slide still, Sarah, thank you. And that the word establishment has been spoken about or determined in the courts previously, and this was back when Woolworths and Ethel Austin went into administration and obviously had to close all of their stores. And the Court of Appeal here said that the word establishment means that it only relates to each of their stores as opposed to the whole retail business. So that means that Woolworths and Ethel Austin did not need to collectively consult with the employees in their smaller stores with less than 20 members of staff. So it's worth bearing that in mind if you are a business that operates from a number of locations, you have a number of premises, then it relates to each of your premises as opposed to your whole business. So we look at collective consultation and furlough leave now. The government guidance on the furlough scheme has been very clear that employees can be made redundant whilst they're on furlough leave. Therefore, it seems that collective consultation can take place whilst employees are furloughed, and employees can be served with their notice whilst they are furloughed. But it's very important that their notice period does not come to an end until at least the end of the prescribed 30-day or 45-day period. So by starting the collective consultation procedure whilst employees are furloughed, this allows a business to absorb some of the cost of collective consultation, because the government will effectively be paying for either all or a large chunk of the employee's salary whilst you are collectively consulting. So if part of your role is to consider the costs of redundancies to your business, then do bear that in mind. Now, if you do this and you do serve employees with notice whilst they are furloughed, whether they need to be paid their full pay during their notice period or only 80% in line with the furlough scheme depends on what it says in their contract of employment. So if when you look at their contract of employment, it says that the notice period you're required to give to employees is in line with the statutory minimum or only 1 week above, then employees are entitled to their full salary during their notice period and whilst on furlough. So that's going to mean as a business, you will need to top up their salary. Whereas if their contract says that they are entitled to in excess of 1 week above the statutory minimum, then they're only entitled to 80% of their salary whilst furloughed and serving out their notice period. So again, that's something to bear in mind if you are calculating the costs of redundancy at the moment. We understand that obviously many businesses are going to be quite reluctant to start collective consultation and inform their staff that they're at risk of redundancy, which is understandable, especially when we've already seen that the furlough scheme has been extended once and it may be extended again. However, if you think it's a real possibility that you may have to make 20 or more redundancies following the end of the furlough scheme, I would not wait too long to start this process because of the costs associated with having to collectively consult for 30 days or 45 days. Because, for example, if the scheme isn't extended beyond the 30th of June and it's only then that you start collective consultation, then you're not going to be able to make these large-scale redundancies until at least the 1st or the 16th of August, depending on how many employees you're making redundant. So that means that you're going to have to pay the salary costs up until that date, and don't forget obviously that employees will also be accruing holiday until those dates that you'll have to pay out as well. And that is also assuming, those August dates are assuming that you start collective consultation on the 1st of July, the day after the furlough scheme is currently due to come to an end. So if you have started collective consultation, and we do find though that the furlough scheme is extended beyond the 30th of June, then there's going to be no problem whatsoever in pausing the collective consultation process so that the redundancies don't take effect until after the furlough scheme comes to an end, whenever that is, if it is extended. And that's because the minimum consultation obligations, 30 days and 45 days, are just that, they are minimum. So if you collectively consult for longer than that, that's not going to be a problem. You know, ordinarily in ordinary times, we might see that employers are reluctant to do this because of the risk that employees are going to say, well, resigning, I'm getting a new job, I'm not going to hang about for you to make these decisions on redundancy. But it's not really going to be a risk, I don't think, in the current situation that we find ourselves in, simply because employees are going to struggle to get a new job in the current climate. So that isn't or shouldn't be a concern for employers about having a particularly prolonged collective consultation. So on, just finally on this slide, the special circumstances defence. I've just put that in because there has been some speculation as to whether the minimum consultation periods can be dispensed with because of the climate that we're currently in. And that's because the legislation says that where special circumstances apply, it is possible to dispense with the minimum consultation periods to an extent. However, the special circumstances defence is a very high threshold to meet, and ordinarily it can only apply where sudden out of the ordinary events happen. So the usual example given there is if a business was to lose one of its largest contracts without any notice, then perhaps the defence could be relied on. And obviously there's no doubt in saying that the COVID-19 pandemic definitely is a sudden and out of ordinary event, but the furlough scheme is not. We've all been given ample notice by the government to say when the furlough scheme is due to come to an end. And therefore, I think businesses should be in a position to be able to say at the end of the furlough scheme whether they think that they're going to have to make large-scale redundancies. And therefore, I don't think it's a defence that employers are going to be able to rely upon. But even if they are, if a tribunal was to say you could rely upon it, then it doesn't absolve all your collective consultation obligations completely. You must still collectively consult where it is reasonably possible for you to do so. So do bear that in mind if that was something you were thinking of already. So if we just look at employee representatives now in terms of who should be consulted with, if your business does not recognise a trade union, then the appropriate representatives that you as a business should be consulting with are going to be employee reps. Now, there are statutory rules as to how they should be elected, so it's not the most straightforward process that you might think it is. And obviously it's going to be made more difficult if employees are working remotely or on furlough leave. So businesses should therefore be thinking in advance how you are going to carry out this fair election process remotely, because otherwise it could give rise to a claim. I think it's going to be necessary to have at least one video call with all employees that are affected to tell them that they are at risk and why they need to elect representatives and how they should do this. And then thought will need to be given as well as to whether it's going to be possible to have a digital election process. So as I said before, if a business wants to make redundancies immediately following the end of the furlough scheme, then the first collective consultation meetings should happen on the 30th or the 15th of May, depending on how many redundancies you want to make or need to make. So that means that in advance of those dates, the employee reps already need to have been elected. So planning fairly soon is going to be the key to get those representatives in place in good time. The fact that we need employee reps has posed the question as to whether this will amount to work whilst furloughed. So the government guidance has been very clear that any employees that are furloughed cannot carry out work, but they haven't said whether acting as an employee rep will constitute work or not. They have, however, said that work amounts to generating revenue for a business or for your employer, or carrying out services for your employer. I think that it's very unlikely that it will be considered to be work acting as an employee rep, just because an employee rep by definition won't be generating revenue and won't be carrying out services. But it may be that the government guidance says otherwise, but we will wait and see when and if that is produced by the government. So the role of the employee rep is by nature to feed back to the employees that it's representing following meetings with you as the employer, to get their views and then to feed that back to you as the employer at the next meeting. Social distancing measures that we're all currently abiding by are obviously going to make that more difficult, but you as the business need to make sure that the employee rep is in a position to be able to do that effectively. So you're going to need to make sure they've got up-to-date contact details, that they've spoken to the employee reps, and that you're able to facilitate a meaningful discussion between the both of them. So I think that's going to be encouraging them to have video calls, so the rep to have video calls with the employees it's representing. So we now look at what collective consultation actually is. The legislation is very specific on this. It first of all says that specific information, written information, needs to be given to the employee reps. Now that shouldn't be too difficult to do if they're furloughed or working remotely, provided you've got up-to-date contact details of the employee reps and you've spoken to them in advance to say how you're going to be providing the information to them. The next stage ordinarily would be to have meetings with the employee reps. Obviously that's going to have to be done remotely at the moment. So again, thinking in advance how you will carry out these remote meetings is going to be key to being able to evidence that you've carried out a meaningful collective consultation process if it was ever questioned. So if you look at the next bullet point, any other obligations, so obviously everything I've spoken about so far is in relation to the obligation to collectively consult, which is the main one when we're talking about large-scale redundancies. But in addition to that, you also as a business need to notify the Secretary of State via the HR1 form, which is available on the government website, that this is your proposal. And again, there are strict timeframes when that needs to be done by. So it's worth remembering those, that obligation. There is also still the requirement to consult individually with employees that are at risk of redundancy. So that goes back to what I was speaking about on the first slide. And the government guidance has been very clear that even if an employee is on furlough leave, this obligation still applies. So again, you need to be thinking about how you're going to be able to do this remotely. Now, if a business doesn't comply, and by doesn't comply, I mean either doesn't collectively consult for the prescribed periods, or doesn't carry out a meaningful consultation, or doesn't elect employee reps in the correct way, then that does allow employees to bring a claim in the tribunal. Now, they would be bringing a claim for what's called the protective award. Now, the protective award is up to 90 days gross salary for each employee, and there is no cap on what their salary could be. So it could be an extremely expensive claim for employers if you're making large-scale redundancies. And to be honest, I see no reason why at the end of all this, there probably will be an abundance of these type of claims for the protective award in the tribunal, simply because these employees will have nothing to lose. There are no fees at the moment in the tribunal for them to lodge a claim, and also if employees are being made redundant now, it's probably going to be some time before they get another job. So why would they not bring a claim in the tribunal if they think that their employer has messed up when making them redundant? And then it is also worth remembering to notify the Secretary of State, like I said, via that HR1 form, because whilst it might just seem like an administrative task, failure to do so is actually a criminal offence which could result in a fine. So definitely one that's worth remembering. So that's an overview of collective consultation obligations when making large-scale redundancies, but it is worth remembering that that also applies if you are making large-scale contractual changes. So if, for example, you are needing to reduce salaries and reduce hours for 20 or more of your members of staff, then the collective consultation obligations will also apply. So do please bear that in mind. So that's everything from me. I'll pass back to Kevin now, who's going to start the Q&A session.
Thank you, Claire. So there are people out there because there are some questions. So I'll start to run through these, and James and Claire, you may feel free to jump in at any stage if there's anything else that you want to add. So the first question was, do you think it's likely that the furlough scheme will be extended beyond June by the government? And so there have been some recent noises about this from the Treasury. And so within the last 24 hours, because of a particular pressure from a few sectors, but from what I see in particular, UK hospitality is one, and also from the airline industry. As you would expect, the Treasury have said that there's no decision that's been taken yet, but the mood music around this is that what's likely to happen is that the scheme will be phased out, that we will be weaned off the scheme, given that currently there are 4 million workers who are currently reliant on it. So it's reported in the Financial Times today that the Treasury are talking to businesses and unions about phasing out the scheme. So I think the first thing is, yes, I think it's likely to be extended. But one option being discussed at the moment is it being gradually cut down. So it might be, for example, that there's an extension so that first of all it's paid rather than 80% but moved to 60%, and then further moved down to 40%. So I think that's what you might expect as the future in relation to the furlough scheme. But as I say, it's not confirmed yet, but that's an indication. The next question is that my business has less than 20 employees. Do you still recommend Zoom meetings to show contact, or is that not required? Well, if you've got less than 20 employees, then so long as those employees have, or some of those employees have more than 2 years service, then they will have the right to bring claims for unfair dismissal. If you've got less than 20 employees, then you don't need to be so concerned, or you don't need to be concerned about collective consultation. Unless, I suppose, it's recently dropped down to 20, in which case, if you are now potentially consulting with 20 more employees, then those previous numbers could be added to your numbers of employees to tip you over the 20. So there are some, so caveat this answer with, it might depend on when it became 20. But if it's 20 and there are no previous employees being dismissed for redundancy in recent times, then You just need to be able to evidence in the right way that you've gone through proper consultation. Whether that's by Zoom meetings is probably not the, that's not the key. The normal rules of fair processes will apply, but you will need to be able to show that you have warned and consulted your employees. The next question, as my business has less than 20 employees, do we still have to have a 30-day consultation? The answer to that is no. If you've got less than 20 employees, you don't need to have a 30-day consultation period. I would generally say that it's tight to try and do it fairly and for it also to look fair if you have a consultation period that lasts much less than 2 weeks. So I would probably aim for a consultation period, but I would also in those consultation periods consult on the period of time. So that's another key thing that I advise clients to do. Is say, when you're talking about the period, clear it off with the employee as part of the consultation to say, this is how long we are planning to consult. Give us your views on whether you think that's too long or too short. One thing that I find from experience is whatever you say, for some people it will be too long because they'll say, you've already made your mind up, why don't we just get on with it? For some people, they'll say it's too short. They'll say, you're rushing this through. So the best thing to do is give people the opportunity to give their view on that so that you hopefully further on down the line remove one area of possible claim. The next question, we could be here all day, I suppose. If an employee is rotated on furlough, so in other words, that they're put on and then taken off and then put back on again, do they need to re-agree to the next furlough period? I would say on that, well, the key, I suppose, is what the terms of the original furlough agreement says. So I think that's where you'll find the answer. For any furlough, there needs to be agreement, and you should be evidencing that, but it will depend on the terms of the original letter. James, I know you've been doing a lot on that. Is there anything that you would add to that point?
Just from an evidential point of view, you might want to get some further notification, some kind of letter that evidences that they've been on furlough, come back and then gone again. But you're right, Kevin, if the original letter allows for it, then in theory you could just take them on and off. But I think, yeah, evidentially, just maybe try and get something else that says you've been put on furlough again and keep a record of that.
Yeah, I think that's got to be the safest advice in relation to that. What notice do we give? Do we have to give if we're looking to change a staff member's contract? Again, when you are changing contracts, just be mindful of the number of people that change applies to. Because if a change applies to 20 or more people, then you are back into collective consultation territory that Claire talked about. But for the purposes of this question, it says it's a staff member. I'll just assume that we're talking about one person. Well, if you're looking to change it and that person agrees, then a change doesn't need to be given really on notice. In the same way that you make a change to an employee's contract when they're given a pay rise, you don't get too many disputes of people who've been given a pay rise and that's you making a contractual change to them and nobody complains about those things. But the same principles of law apply. So if you're making a change and it's an agreed change, then it can be done, should be evidenced, should put it in writing, but there's no notice that's required. If you need to try and force through the change, then the notice that you need to give is usually the contractual notice to terminate the contract. So be careful about that. It's kind of become the last option really in terms of trying to force through a change, because if you force the change through without that person's agreement, and they've got more than 2 years service, then those are the conditions in which constructive dismissal claims arise. But if that's what you need to do, as some businesses might need to do, then if somebody's got a notice entitlement under their contract to terminate the contract for a month, and you haven't been able to get agreement, but the change is reasonable and you've consulted, then you would give a month's notice. And then if they don't agree the change, then their employment terminates and you offer them re-employment upon the new terms that you've been seeking to persuade them to agree to. Now I'm reading these questions for the first time here, so who knows whether or not I'll know. So the next question is: a member of my staff is currently on furlough, has been called for jury service. What do I need to do? Well, do you know? Frankly, I don't have.
I'm surprised there's any jury service required at the moment, though, because I would presume most trials won't have anybody in attendance. So it's a bit surprising.
Well, I suppose the question, by its very nature, must mean that that jury service is being called for, and I know that members of the judiciary have been included as essential workers for testing. So there is testing that's going on. Maybe while I'm dealing with the next couple of questions that I've got, James or Claire, you'll look that up.
Yeah, it wouldn't be considered to be work for just what I was saying about what's considered to be work for the purposes of furlough is obviously generating revenue for the employer or carrying out services for the employer. Jury service is doing neither of those things for the employer, and therefore I would imagine you could still reclaim their salary from the government via the furlough scheme. It's quite a niche question.
Yeah,
makes sense. And I will go with that.
What I might suggest is that the person who's asked that question obviously has asked it anonymously. If you want to get in touch following the webinar, perhaps we can do a bit of research on that. I myself have done jury service twice, and I don't know if there'll be a complication because normally you claim your salary back from the government during that time anyway. Yeah, but perhaps if that person could email us separately, we'll get an answer for that. And
well done, generally. I think you're the winner. You asked the question that I can't.
The prize is everyone being uncomfortable.
So, the next one. Within the CJRS, the Coronavirus Job Retention Scheme, if someone is being furloughed during April but returns to work during May, is there a minimum of 3 weeks of being furloughed in May that are needed to be able to claim under the scheme in May? No, it doesn't need to be in the claim period, so long as the furlough period isn't less than 3 weeks. Then you can continue to claim. I hope I've understood that question correctly.
Yeah.
If you haven't, then feel free to ask the question again in a different way. I think then we might be on to the last of the questions. So thank you very much for these. If we did go down the redundancy process and redundant as of the 1st of July 2020, however, the furlough scheme is then extended to, for example, the 1st of August, can you extend the leave date or still process the redundancy as at the 1st of July? Another good question. So I think that it would be possible to extend the scheme or extend the employment. It's what's happened effectively already in many instances for employers under the scheme. I think that might well depend on the guidance, though, that comes along with any extension. So I suppose it probably comes back in some ways to Claire's point, which is you can pause the consultation process. What you can't do is, if you've given notice, is that you couldn't retract the notice without agreement from the employee. So in some instances, of course, it might be right for an employee to say, actually, now I have found another job and it is worth my while to take my notice pay and my redundancy pay and my holiday pay, all of the payments that are due at the termination date, and then move on to another job. So there's it's likely that there will be some agreement required, but I would also say that that all of that will have to be subject to the guidance. And I know by the very nature of this, you're all on this webinar because you appreciate that. I'm sure that, as James had said, it's a bit of a moving target. Remember, there've been there's lots of guidance being issued, four pieces of guidance, and then the guidance amended 4 times, and then a new Treasury direction. I'm sure there will be more. So these are things to keep on top of, and that's something that we'll be doing. That is the last question, unless anybody did in those intervening minutes find out anything more about jury service that we could deliver. If not, then thank you for sticking with us through this. I think I've only had one delivery in that, but I was muted, so that worked. We've got other things that we're doing. Sarah mentioned the other support that we offered. For those of you that attend our HR breakfasts that you can sign up to through Eventbrite, the next one is scheduled to take place on the 4th of June. They're usually held at our offices at Blackfriars House in Manchester. It seems unlikely that will be happening as a face-to-face event, and so if it isn't, then we will be doing another webinar when hopefully we'll be even better than we were today with all the technicalities. I think, Sarah, that's it, isn't it, from us? There will be a follow-up email asking you for your feedback. As always, we're really grateful for the feedback that you give us on the ways that we can make these events better and produce things that are useful for you. And unless there is anything else from anyone else, then thank you. And thank you to Sarah and to James and to Claire. And that's us done for today.
Thanks, everyone. Take care.